If you're going through a separation or divorce, then you might be wondering, what are the alternative methods of dispute resolution and how do they work? In this video, I'm going to explain the different types of alternative dispute resolution, or ADR, and why they may be a useful tool when considering divorce or separation. I'm Faye Donald, a partner at Raeburn, Christie, Clark & Wallace. The rise of Netflix box sets such as Suits and The Good Fight leave viewers with the notion that the courtroom is a place for vindication and that it is an attractive forum for resolving disputes. The reality, however, is that for a number of reasons, not least cost, litigation often leads to a far less desirable outcome than expected for either party. The drawbacks of litigating family law cases include the length of time which it takes to resolve matters, cost, what is said in court cannot be unsaid, family members may feel forced to take sides. It is stressful not only for the parties involved but also for their children and wider family members. Additionally, by having their day in court, parties are allowing a sheriff, someone who is a stranger to them and has little knowledge of their family and their particular circumstances, to make potentially life-changing decisions for them. There are, of course, circumstances when going to court is unavoidable. However, in the majority of cases, resolving matters out of court can be quicker, more cost-effective and less stressful. There are a number of different options available. The collaborative law process is a non-confrontational way of making practical and legal arrangements arising out of separation. It does not rely on decisions imposed by the court, instead allowing couples, through supported discussion, to reach agreements which are in their best interests and those of their family. At the start of the process, the parties and their respective collaboratively trained solicitors sign a contract known as a participation agreement, which, amongst other things, gives a commitment to trying to resolve their issues without going to court. The solicitors appointed are prevented from representing parties in court if the collaborative process breaks down. The process is conducted by the parties and their solicitors attending a series of four-way meetings, and as well as their solicitors, both parties will have the opportunity to work with other collaboratively trained professionals, such as financial and family consultants, who can provide specialist help regarding financial matters and emotional support if required. Parties agree to exchange information openly and honestly, and that they will shield any children of the relationship from their disputes. The aim of the collaborative process is to reach fair and positive outcomes for both parties. Mediation aims to reduce conflict, improve communication, and to agree arrangements which are practicable and workable for everyone. This process requires each party to attend an individual appointment with the mediator, where the process will be explained and the mediator will note the issues to be dealt with. Thereafter, a joint session will be arranged where the mediator assists the parties in generating options to resolve their affairs. The mediator remains impartial throughout the process and does not act as a judge or impose decisions on parties. Mediation facilitates communication, which is respectful and open, and crucially, it is confidential and cannot therefore be referred to in court proceedings. At the end of the mediation process, the mediator will prepare a summary of what has been discussed, which identifies the issues dealt with so that hopefully it might assist in the preparation of a separation agreement. Arbitration has more traditionally been used in the commercial world, but with the introduction of the Arbitration Scotland Act 2010, it is now part of the mainstream methods of dispute resolution for family law matters. The Act allows most disputes between separating couples to be referred to a mutually chosen arbitrator, and arbitration offers an alternative to court where a decision is required. Both parties must agree to arbitrate and will be bound by the decision of the arbitrator. That decision carries the same weight as a court judgment. The benefits of arbitration include that where one particular issue is hindering progress, the arbitrator can be asked to make a determination on that issue. It may also be possible to keep matters confidential and out with the public domain, which is becoming increasingly important to clients. To find out more about divorce, separation agreements, or arrangements for children following a separation, you may find other videos in this series helpful. To start a conversation with one of our knowledgeable and friendly solicitors, simply follow the link in the description below to fill out a contact form, and we will contact you to discuss your particular requirements.